Get ready for the dictation. 1, 2, 3, start. Without adjudicating the petitioner's petition on merits, we are of the considered view that interest of justice would be best met if the petition is disposed of in the following terms. Since the vehicle in question stands seized in relation to the FIR which stood registered long ago, in case confiscation proceedings has not been initiated, it must be initiated within a period of 15 days from today, and that confiscation proceeding stands initiated. We direct the appropriate authority under the Act to forthwith ensure that such proceedings be concluded not later than 30 days. The petitioner undertakes to make himself available in the office of the concerned appellate authority empowered under Section 58 of the Act, that is, District Collector, in his office on 4/2/2020 at 10 am. We further direct the appropriate authority to positively conclude the confiscation proceedings within next 30 days on appearance of the petitioner. If for whatever reason such proceedings cannot be concluded in that event, it shall be open for the authorities to take such measures as are permissible in law for release of the vehicle in question by way of interim measure on such terms as may be deemed appropriate, considering the attending facts and circumstances of the case. If eventually the appropriate authority arrives at a conclusion that the property is not liable to be confiscated, it shall be open for the petitioner to seek damages in accordance with law and have appropriate proceedings initiated against the erring officials. Land Council for the petitioner states that the certified copy of the order shall be made available to the concerned district collector on the date so fixed. For further guidance, where parties have not approached this court, we issue the following direction. The expression reasonable delay used in Section 58 of Chapter 6 of the Act, in our considered view, necessarily has to be within a reasonable time and with dispatch, which period, in our considered view, 3 months' time is sufficient enough for any authority to adjudicate any issue, more so when we are dealing with confiscatory proceedings. We clarify that we have not adjudicated the writ petition on merits, and it shall be open for the parties to take a stand in the adjudicatory proceedings, and whenever parties are aggrieved, it shall be open to them to initiate appropriate proceeding before the appellate authority. Land Council for the state also undertakes to communicate the order to the concerned appropriate authority, that is, district magistrate empowered under Section 58 of the Act. It is seen that despite our observation, the appropriate authorities have not taken any action in initiating the proceedings for confiscation of the property under the Act. The litigants are thus forced to approach this court by way of filing separate petitions. Thus, today we are left with two options: either to initiate proceedings for contempt under the provisions of Contempt Court Act or under Article 215 of the Constitution of India, or ask the Chief Secretary, Government of Bihar, to evolve a mechanism self-serving in nature so as to ensure that the provisions of the Act are implemented in letter and spirit expeditiously, without any delay and without reasonable dispatch. Why is that the owners of the property are forced to approach this court for release of the vehicles or property? Is that there is no mechanism under the Act for initiating confiscatory proceedings at the earliest? Is it that there is insufficient infrastructure with the state government for ensuring implementation of the provisions of the Act? Illustratively, in the weekly list dated 27/1/2020, we notice that more than 75 cases stand filed and listed despite our order dated 6th of January 2020. In the instant case, seizure is of the year 2019 and no proceedings of confiscation have commenced. We are of the considered view that non-implementation of the Act is generally having a very serious adverse consequence on the dispensation of administration of justice, and peculiarly it is only when the matter was taken up by the bench hearing the petition bearing CWJC number 21365 of 2019, Ram Kumar versus the state of Bihar and others on 18/12/2019 that the state vehemently opposed release of the vehicle contrary to the practice adopted hitherto before. Be that as it may, at this point we remain from passing any order under the contempt jurisdiction but direct the Chief Secretary, Government of Bihar, to file his personal affidavit dealing with each one of the issues highlighted supra, as also elaborately indicating the mechanism which the state has or desires to evolve so as to prevent the litigants from directly approaching the court for release of the vehicle and also ensuring early completion of the proceedings, be it confiscatory in nature or in an appellate jurisdiction under the provisions of the Bihar Prohibition and Excise Act 2016. Let an affidavit in that regard be positively filed within 1 week. List this case on 6/2/2020. Stop.